Looks like the parties are ready. We're here in the matter of State versus Erdman. And for the applicant, we have Denise Gonyea.
May it please the court, counsel. I'm Denise Gonyea, and I'm here on behalf of Appellant Dagger Erdman, requesting that the Supreme Court find that the juvenile court, the lower court in this case, abused its discretion in entering its order denying, granting the state's request to move Mr. Erdman's case from the juvenile court to the district court to try Mr. Erdman as an adult. The United States Supreme Court has instructed us that children and adults are constitutionally different. And this is reflected in the Iowa legislature creating statutory differences for the prosecution of minors either as delinquents or minors as being waived into adult court. In this proceeding, the state chose to initially file the charges against Mr. Erdman in the juvenile court and contemporaneously submitted its request to waive into adult court. The juvenile court then in Washington County, then set a hearing on the matter, and in doing so, heard argument from the state, which included testimony from the juvenile court officer, and basically found, without going through the necessary steps, that Mr. Erdman would not be able to complete the treatment that would be required in his case prior to turning 18. While Mr. Erdman's attorney did point out that under the statutory scheme, there was still a year and a half, 18 months that the court would have, the juvenile court would have to provide treatment and jurisdiction over Mr. Erdman, that because he would not be able to attend the state training school, it was not appropriate, essentially.
Seen that?
Seen a person go into the state training school?
The proposal you're talking about, that the juvenile court would keep them, if there wasn't a waiver, and you've got 6 months, and the program takes, I don't know, the testimony I think of the JCO was something like much longer than that. Have you ever seen that?
No, I haven't seen it.
The reason I'm asking is because the word reasonable is used. So I'm just wondering, is it reasonable for something like that to happen if it's never happened before? Juvenile court, the testimony of the JCO was, we would lose jurisdiction if the child doesn't do what he's supposed to do before 18. We have no clause. So I'm trying to wrap my head around, how would that work?
Well, I guess the answer to that is a couple-fold. First, in this situation, it's the state's burden to show that the child could not be remediated in some way.
I could find it if I need to, but the JCO's testimony was something to the effect of, there is no placement as a juvenile for this program. I don't think she probably has to prove a negative. By saying there's nothing, how can that be?
Well, I would point out that she said that the general procedure would be that Mr. Erdman would undergo an evaluation, and generally the treatment would take at least 6 months.
So I believe this is what she says. The question is, for any of the other programming involving the child in terms of sex abuse treatment that you've dealt with, would any of those allow the child to remain after age 18? Answer, no. So if there's the state school is unavailable, and there's no program that this witness is aware of that would allow continued treatment after the age of 18, specifically for sex abuse, which is what's at issue here, then what options would be available?
Your Honor, I would submit that there would need to be some sort of hybrid program if for some reason he aged out of a program that was available to him prior to the age of 18, then he could simply continue on. And I guess I would put it in this context. The juvenile court, of course, is in the delinquency category is for treatment and prosecution of crimes committed when a person was a child, but it is not a court that is exclusively having jurisdiction and control over only children, meaning when a person is an adult, a person could be reverse waivered, for instance, into jurisdiction in juvenile court. And of course, when that happens, the juvenile court can require this adult person who's over age 18 to have treatment for 18 months. And I think this would be a similar situation here.
Aside, what's the remedy that you're seeking?
Your Honor, the remedy would be that Mr. Erdman would have a new waiver hearing and would be able to present the factors to the court to see if he would be, especially under C, as
Conviction.
well, Your Honor, I think that in order to resolve that, I would cite to State versus Rubino, which is mentioned in the dissenting information from Judge Tabor. But in Rubino, what ended up happening is that the Iowa Supreme Court remanded to the district court to have a waiver hearing, and if their waiver was granted, then there would be a vacation of the conviction, and it would go into juvenile court. However, if upon the waiver hearing it was decided that it was not appropriate for juvenile court, then the conviction and sentence would stand, and I would argue.
Let's assume we remanded it for a new waiver hearing. Is it on the same record that was developed years ago? Or is it a waiver hearing on the current facts? And if it's the current facts, how old is Mr. Erdman now? And how old would he be 6 to 9 months from now at the time of this new waiver hearing?
Admit that under State v. Duncan, the record would potentially include new facts, including his behavior between the time of the original waiver hearing and any compliance that he had had with his ongoing district court sentence, which it has included a treatment program.
Following up on Justice McDonald's questioning, I mean, don't we have to focus in on the waiver hearing that already occurred? And the issue there is on the record that the juvenile court had before it, did the state establish there are not reasonable prospects for rehabilitating the child if the juvenile court retains jurisdiction over the child? On that record, wasn't that established?
Your Honor, Mr. Erdman's position would be no, that was not established. In the written ruling from the court, which is required from the juvenile court, the order simply reiterates the required standard, such as the nature of the offense, but doesn't go into a analysis of why, for instance, it is in the best interest of the child that he would be waived to adult court. It does not go into the best interest of the community.
It's a lot. The judge's order says, after hearing the evidence and argument of counsel, the court takes the following into consideration, and it lists the statute. So whatever happened between his 2 ears, isn't that a form of analyzing whether he puts it on paper or not?
Your Honor, I would submit that in both respects,
Any requirement, statutory or otherwise, that he has to state exactly what his reasoning was, or what his thought process was.
I believe the statute says that it has to be in writing.
But I'm talking about the analyzing.
Well, I would submit that in many cases, the standard as to whether it is the writing is sufficient is whether a court of appeals can make a ruling on what was laid out. And I would submit that the record.
Here's a little bit what troubles me. You had the JCO came in and gave an explanation why there was an alternative. State training school, he's not a candidate for that. And the other options he can't complete before he turns 18. And that was the record. And then there was nothing else presented, and the court said, in effect, the state's made its case that they're not reasonable prospects, and in effect, it's in the best interest of the child, and therefore, we're going to waive to adult court. And now what I hear you saying is almost like, well, I'd like to have a do-over so we can go and show that there are maybe potentially some other alternatives. And that's just not the way hearings and trials work, kind of, right? I mean, the record is the record. You make the record when the hearing is there.
I understand where Your Honor is coming from. I would say that, one, we have the case law from State versus Rubino, and State versus Duncan, which does in fact say when it's remanded that there can be a record reopened. And to some extent, they leave that to the district court, whether there would be enough record.
So whose burden is it when the JCO testifies that there aren't any programs that would fit this person? Whose burden is it to then come forward and say, well, yes, there really are?
Your Honor, I would say in a waiver hearing versus a reverse waiver hearing, the burden is on the state to provide the judge enough information to actually weigh the programs, because one of the things the judge has to do is compare what programs are there if the person stays in juvenile court, and what programs are there if the person.
She testified, she was asked about it, and her answer was, if he would not be able to do the service within the community, we don't have a placement facility other than the state training school. And so she's saying there isn't any place other than state training school for the type of program that sex offender treatment requires. Let's play a game of pretend here. If the kid is 17 and a half, which is about what he was at the time of the waiver hearing, 17 and 1 month at the time of the incident, and he's not waived. Let's assume that the judge denied the state's motion for waiver. If he can't go to the state training school, then there's something called the problematic sexualized behavior beds, which is kind of what juvenile court does for a pretty serious program. Doesn't there have to be a policy exception for that child to have such a bed? And my point, kind of the original question I asked you, have you ever heard of that happening? And once again, we're back to the word reasonable.
Your Honor, I believe that it was incomplete for the judge to conclude that the only possibility would have been the state training school, and because this was not a serious enough, as far as his history, offender, then the only way he could be handled was transferred into adult court. As far as saying reasonable, I guess I'd like to draw a distinction between what's reasonable and what's constitutional. I mean, the legislature wants children and adults to be treated differently.
For placement all the time in juvenile court. And just because a parent or a lawyer can think of a great idea, and maybe it would help the family get back together, if it's not reasonable. For example, let's say somebody says, there's a program out in California, it is exactly what my kid needs. That's awesome. But that's not reasonable for somebody from the state of Iowa. So that's why I'm asking you, if you've never heard of it yourself or seen it, wouldn't that be reasonable to say perhaps not?
I would hate to agree that putting a legal definition of reasonableness on what programs are available, because that's really not something my client has any control over. I mean, that's really going to be up to what has been funded, what has been provided, and he just is not in a position to know all these things about what could be available, or maybe he doesn't have parents that are wealthy enough to look into, well, can we send him to California, or does this insurance cover this? Because that's part of what it comes down to, too. If they're treated in this particular way, then is it insurance? Can they be? Just in closing, I would just point to, in particular, State versus Duncan and State versus Rubino, that the proper consideration for my client would be to provide him an adequate waiver hearing that looks over all of the required analysis, and if the district court decides that, or the lower court decides that he should stay in juvenile court, then there should be a vacated conviction. Otherwise, the conviction and sentence that he has would stand.
Yeah. Ms. Reinkoester?
May it please the court? I do want to talk about the waiver hearing and what happened there, but I want to start with my notice of additional authorities. And that's because when I started preparing this case last week, I made a discovery, which is that we made a mistake at the juvenile court.
With placement of a child at Eldora.
This is, well, partially that, but partially this too. That the defendant was 17 years old at the time he committed the crime, and he was charged with a forcible felony. And under 232.81C, the district court has original exclusive jurisdiction over such crimes. So that leaves us in a little odd place, considering that because we mistakenly started these proceedings in juvenile court, the defendant actually received more process than he was due.
To talk about. How about 232.52 sub 2E? If a child is at least 12 years old and commits a forcible felony, you can get into the state training school.
That is also correct. I do.
Board rule.
I read that, and I also included that in my notice of additional authorities because I was reading that as well, which is that it's either, you can have admission to the state training school if you commit a forcible felony, certain conditions under, certain crimes under 124, and then otherwise if you meet 3 of the 4 criteria.
Things right then and there. First of all, that the juvenile court probably committed or could have committed an error of law by saying kid cannot go to state training school because he didn't satisfy 3 out of 4. And it looks like that code section I just cited said, yeah, he could have. And then secondly, the original jurisdiction question, where do we go from here?
So, well, where do you want me to start?
To that though, even if, part of this I think is, like you said, the state is the one that brought it in juvenile court and then immediately moved it. And I agree with you that it should have started in district court. But had it started in district court, there still could have been the same waiver hearing. It just would have been by the district court rather than the juvenile court. Is that right?
In district court, the defendant can apply, make a motion for a reverse waiver hearing. Now, that's not mandatory like it is in juvenile court.
It could have happened.
But then also the burden shifts, which is that then the defendant has the burden of proving that he would be better served by the services in juvenile court than in district court. And in terms of, Chief Justice Christensen, your questions, I wonder, I've been thinking about this all week. What does it mean that we should have filed this in district court in the first place? And now we have a defendant complaining of an error in a proceeding that he's not legally entitled to. And I think what it boils down to is that, the state sought jurisdiction in the district court. District court always should have had this case. It was the court that the legislature, wanted this case to begin in and carved out jurisdiction for this case. He has a legally, rendered verdict against him in this court. So I'm not sure that even if there was an error in the waiver hearing, which I don't believe there was, that there can be a remedy applied because of sort of the procedural posture of this case.
The other code section, the 12 years old and enforceable, let's just think of that alone. Is that grounds for itself to go back?
Maybe. I don't know the answer to that. But my response, if it would.
Life into it at that point?
My response would be that we have sort of a strange review on these types of cases, which is that the decision itself is reviewed for an abuse of discretion, but the facts have a de novo review at the court. And so I think it's possible that this court could de novo look at the facts of the underlying case and decide whether or not that option would have even been available in this case for this particular person. Now, simply because statutorily he qualified because of the forcible felony to perhaps have placement in the training school, we only had 6 months left. And if we account for how much time it's going to take to have an adjudicative hearing, to have a dispositional order, to have an evaluation, which there's wait lists for, in order to determine what the type of treatment is available to him, and then assuming that there is even space available at the state training school at the time that it was ordered, the 6 months is a sort of a wish to get somebody in that quickly.
Period play out in all of this.
The district court, the juvenile court, when someone's 17 or older, can retain jurisdiction over the child for 18 months. But so it's my understanding that then the court could impose as part of the disposition sort of probationary terms. You go to this type of treatment. You go, you just like regular probationary terms. The problem then is that if after the child turns 18, they fail to comply with any of those terms, the juvenile court really no longer has much authority to enforce.
Training school and were extended beyond 18.
In the state training school prior to turning 18, then the state training school can apply to have him stay for 18 months past his 18th birthday. That's correct.
If he had been sent there right then, right? 6 months shy of 18?
But that's part of the issue, is that he couldn't have been sent there right then.
Right then, but he could have been adjudicated and already part of the system, correct? And even ordered for placement?
Assuming that that could all be done, but that's the other part that I was trying to bring in, is that there are practical considerations involved in that, which is the assessment, the evaluation, and assuming there's even a spot available at the state training school. And of course, that is now even more limited than it used to be, considering the consent decree in federal court.
Doesn't the evaluation and the placement also have to do with whether or not a child has admitted? Yes. And that's never happened in this case?
It's not even in his PSI, correct. And that's a major concern in this case. I think, of course, the juvenile court has to look at only the information before it at the time of the waiver hearing to make this decision about whether or not, the child should be waived to district court. But I think that all of the information that has come in since that time only supports the juvenile court's decision to waive him. We have just a consistent denial on his part that anything happened, or ludicrous explanations for how it possibly could have happened. And then his focus has always been on the fact that the victim told anyone about this and that he's facing any kind of consequences. He's never once accepted any responsibility for what he did in this particular case. And so I think everything that's happened since the waiver hearing, has only validated that decision. And especially, I think the outcome in this case was probably the best in terms of his interests and the community's interests, because he's now on extended probation. He has 5 years of probation. He has got 1 year in a residential, treatment facility for sex offender treatment.
Hanging over his head right now, a suspended sentence, and can go to the pokey for a long time. So we need to figure out what should this court do if juvenile court lacked jurisdiction at the time, it did what it did. Even if everything got done and the end result maybe would have been the same, we don't know that for sure.
You mean the waiver?
I mean, if he would have been started in district court, we don't know if he would have been reverse wavered. We don't know if he would have stayed in district court. If he had stayed in district court on that path, probably would have been a different jury, different day. My point is, you can't assume that it would be the exact same outcome as what you've experienced thus far.
Assumption, but I just think the record as we have it bears that out. But this also just takes us back to the fact that this case legally always belonged in district court, and that's where it ended up. And and that's also why I cited Emory and the Woodbury County cases about how transferring the authority to the correct court is the proper thing to do when a case is filed under the wrong docket. That's what happened here. It wasn't in the typical manner that it would have happened, but it did happen. And so if you were considering remanding this for,
Okay, let's say that had happened. In my experience, district judges who were never juvenile court judges might look at it differently. There might have been a waiver. Sometimes district judges who have never been a juvenile court judge think, send it back there. It could have gone back. I don't think we can assume just because it ended up in district court that it would have stayed there, because another judge, a district judge, would have been ruling on that.
also, this is complicated because we are all now existing in a world of counterfactuals, which is that maybe he would have had a reverse waiver hearing. Maybe he could have presented enough evidence to prove that he should have been rehabilitated in juvenile court. Maybe he would have gotten reverse waiver back. But then we're in the same with the waiver. He had a hearing he wasn't entitled to. If we send it back for another waiver, discussion, we're also existing in a world of counterfactuals.
I mean, a judge is a judge, and he got a waiver hearing under a more favorable burden of proof. And if he really was legally a candidate for the state training school, I think the JCO, it seemed to me, had some concerns about whether pragmatically he was a candidate as well. That would have been up to his counsel to urge that option, which didn't happen. So can't we just, hold our nose and affirm?
I'm not sure I'd put it quite that way, but yes. So that made me think, and I just have to think back what I was thinking about when you, right.
Is there any basis for vacating a final conviction due to an alleged error in a proceeding that never should have happened? That's the issue, right? Is like we're arguing about an alleged error in a proceeding that never should have occurred, and we're dealing with a district court that had statutory jurisdiction over the crime that entered a final judgment, period, full stop. It's kind of a harmless error case.
Would put it. Or even there's like a little bit of a flavor of a mootness here. It's not moot, but it's complaining of an error in something that the person was never entitled to in the first place. And so, yeah, I think if you look at Emory and the Woodbury County case, they talk about how these issues can be, any errors in juvenile court proceedings can be alleviated by consent, waiver, or estoppel. Now, I don't think consent or waiver are at issue in this case, but I think perhaps estoppel is, simply because of the procedural posture of this case.
Parties below operating under a mistaken assumption that he was not eligible for the state training school because he didn't have prior, violations or convictions. And isn't applying the wrong legal standard itself a form of abuse of discretion? So do we do a remand for a new hearing on something, or are we going to end up in the same place?
I would just go back to what Justice McDonald just said. I think the answer is that it doesn't matter if there was an error or not at this point. But if you were, inclined to disagree, I do think that it is error for the court to not have considered that particular option. I think I would probably liken it to a sentencing case where maybe, the district court judge failed to consider one of the sentencing options, but we also...
You have a kid, 17 and a half, committing a Class B felony, going to school, not a behavior problem, C student. It would be hard for me as a juvenile judge to say, Class B, 25 years. I mean, I would do whatever I could to try and keep it in juvenile court and provide services. And I think if there had been an out, that I cannot imagine that wouldn't have probably been enough to tip the scale. So I think that two out of 4 instead of 3 out of 4 is critical in how you even got a conviction.
So, I mean, obviously we're under abuse of discretion, so we're talking about, and everybody can,
Judge and everybody was operating on an incorrect analysis of the statute.
I'm saying that reasonable minds can differ under abuse of discretion standard, you know, in terms of which judge would rule what. But in terms of this particular case, I do want to point out that, you know, this is a 17-year-old who committed a forcible felony against a 9-year-old. So the nature and circumstances of the crime itself under our case law weigh heavily in favor of waiver. And then also, you know, he does rely on the fact that he never had any contacts with the juvenile system before. But if you read the CPC report that was admitted into evidence, there was information provided that he had been doing this to other girls in the neighborhood. So while he may have never been busted for it before, the juvenile court was certainly within its rights to consider the fact that other girls had.
Nobody testified about that. Nobody brought it up. I saw it too. It's a morsel in that document. I saw that too. But to hang our hat on that.
I think that those three exhibits were admitted at the hearing. The juvenile court said it was taking time to review the entire record and make its determination about what to do. So,
Before your time's up, the sentencing, Judge Gookin suspended his 25 years. Am I correct that the kid was eligible for deferred judgment because of his age at the time of the crime?
901-513, he would have been eligible for either a suspended sentence or deferred judgment. But I don't think I don't even think if, I could be wrong, but if you check the sentencing transcript, I'm not even sure his counsel argued for one. I think they argued for a suspended.
For deferred, but regardless, I just wanted to make sure you agreed with me that he could have gotten it, but the judge chose suspended.
The severity of the event and the fact that he refused to take any responsibility for it. And we would just ask on this that we would affirm the defendant's conviction and also the waiver order from the juvenile court. And, you know, if you were inclined to think for whatever reason that that there was an error in the waiver order, that we would just ask for it to be remanded. I think to have the juvenile court reevaluate its order not to have a new sentencing hearing. And if you would just give me 1 second, and I will say that's because in Rubino, I think that is an interesting case because the reason that went down for another juvenile court waiver hearing was because the lawyer never came for the juvenile. And so he got an entirely new waiver hearing. I'm not sure in this particular case it would merit an entire new waiver hearing, perhaps just a reconsideration of the order.
Sure, you're asking for a remand to go back to juvenile court knowing that you don't have jurisdiction, that it should have started it in district court?
I'm saying that because of that, this case should be done. That it is an error in a proceeding that he was never legally entitled to have. But what I'm saying, I'm pointing out that if you disagree with that position for any reason, and you are inclined to give him a new way, you know, to have a reevaluation of the waiver because you disagree with the fact that we believe with that position, then I think it would just be for a reevaluation of the order.
Error of law, we're done, still has a conviction. Thank you.
I think justice was done here in the right court, and that's all that matters. Thank you.
Anya? Talk about.
Yes, Justice, thank you. With regard to the forcible felony issue, in that lens, the proper procedure here is, one, the state has stated that a reversal waiver is not something that my client was entitled to if he started out in district court. Well, that's not accurate. He's certainly entitled to it. It's not mandatory, but it's certainly a denial of due process to not allow him to have that chance at reverse waiver hearing.
The argument that even if we sort of assume that world happens, where he's in district court, gets a reverse waiver back, didn't he already get his juvenile court hearing? I mean, can't we kind of start there? That he's already got, even if we sort of kind of follow this hypothetical through, he already got to juvenile court. And so
Well, Your Honor, in response to that, I would say the juvenile court would not be the one doing the reverse waiver hearing. That would be the district court, and it would be under a different standard. And because the burden would then be on him, his counsel would be on notice that, well, I better come up with some programs that could be available to him to show the judge in this district court reverse waiver hearing that it would be appropriate for him to go back to juvenile court. And then once he got back to juvenile court, it wouldn't be a waiver hearing, it would be an adjudication hearing, a disposition hearing, which would have completely different standards. And then I would just like to add quickly, as far as there not being, this being a harmless error, there's one huge difference, glaring difference for him. While he may have received a suspended sentence, as an adult, he has a lifetime sex offender registry requirement, whereas if he went into the juvenile court, there would be some discretion there whether it would be appropriate for him to have an ongoing sex offender lifetime requirement versus some discretion to the juvenile court. And when a person is 17, 80 years on the sex offender registry makes a big difference.
Let's continue with this. If we would send it back, remand it, and as Justice McDermott said, make them do what they kind of have already done. And let's assume if it's back at juvenile court for a new waiver hearing, and let's assume everybody plays by the rules and realizes at the time of the incident he did qualify for state training school, that still is a judge's decision whether or not to place him or her or send them there, correct? It's not a mandatory thing that if you are less than 12 and commit a forcible, you shall go to Eldora. That's not a forcible or a mandatory thing, is it?
That it is mandatory.
Record would reflect and flesh out that even knowing those things, the record supports the judge's decision. What do you have to say to that?
I would respond that the juvenile court judge would be on notice that he committed an abuse of discretion in his first ruling, and then be appropriately on notice to consider the full statute and records in an additional hearing.
Think about our remand instruction for what you're asking is for this court to remand this case to the juvenile court to conduct a hearing, which by statute, it doesn't have jurisdiction to do. And then if it redoes this statute or this hearing, the statute specifically says it shall be excluded from the jurisdiction of the juvenile court. So we're going to remand the case to hold an illegal hearing. And then if the judge decides that he would have reached a different result in an illegal hearing, then we're going to vacate a conviction. That's what the remand instruction should be.
Your Honor, I would argue that the remand instruction should be what is in State versus Rubino, which it should be remanded back to the district court for a reverse waiver hearing. If the district court decides that reverse waiver to juvenile court is appropriate, then the conviction should be vacated. If they decide that it is not appropriate, then the conviction and sentence should stand.
But we consider the reports of other girls that he abused them, or is that like a unproven allegation that sentencing courts are not allowed to consider?
That would be something that would not be able to be considered under, for instance, the federal scheme of United States versus Booker, in which the court cannot take as fact something that would increase a person's sentence, essentially, that it would have to be shown beyond a reasonable doubt.
Back to the thing that we're talking about now was raised in the notice of additional authorities. This is a court for the correction of legal error based on the arguments that the parties have raised in their appeal. The issue that you're raising in this appeal is a sufficiency of the evidence with respect to the waiver hearing that occurred, and then the sufficiency of the district court's findings as a result of that hearing. You haven't raised in this appeal whether or not there should have been a different waiver hearing or some other procedure, right? I mean, as this is briefed, the only issue is what is the legal consequence of the hearing that was actually held not the hypothetical consequence of a hearing that should have been held, right?
That, Your Honor, that's correct, and I would say that the error was preserved in just that the argument is that the juvenile court made an abuse of discretion. Certainly, this additional case law and the forcible felony issue enlarges that, but here's with regard, and I don't know how that got this far with nobody noticing after like 6 attorneys and as many judges, well, what about this forcible felony issue? Well, that's a big thing that has surfaced at this point, but if this court doesn't address that kind of in the scheme of Rubino, ineffective assistance of counsel, well, nobody, not even the Iowa's Court of Appeals seemed to have noticed the forcible felony issue. So it's hard to say his attorney was ineffective. Prosecutorial misconduct. Well, obviously the prosecutor wanted it in district court to begin with and made a mistake there in not filing it in district court. So it would basically evade correction of this error if the Supreme Court today decided, well, this isn't exactly briefed in this certain manner, but of course the court has its authority to, once something is brought up, to have some different reasons as to why a final decision is reached. And I would say that it is definitely that the juvenile court abused its discretion is properly before the court today.
Oh, go ahead.
No, go ahead.
All right. I'm going to do something I don't normally do and ask a question after the red light. The disposition that is before us is a lawful, in the end, a lawful legal disposition of Mr. Erdman's situation. It may not be the one that obviously you and your client want, but it's a lawful legal one, and it's a final one. In the course of getting there, everybody had a misapprehension about this legal point about whether he qualified for the training school. Not just the court, but the lawyers on both sides. Isn't the issue now waived?
You're,
If this position is lawful, we don't, do we go back and redo it over something that nobody complained about?
I would cite to, I can't remember the name of the case off the top of my head, but it did say that if the defendant enters a guilty plea in district court, then they've waived this argument. But in my case, my client did not waive. He did, in fact, have a jury trial. And I would also point out that there are oftentimes cases where the violation of due process was so egregious that even if we are pretty sure we eventually got to the right place, we can't just leave it. We can't just say, well, any other time that this happens, and this gets filed in juvenile court and there's this gross abuse of discretion and nobody seems to catch it until someone happens to ask for further review and your honors see what's going on. It's something that needs to be remedied for our judicial system for not just this case, but in going forward.
Chief, can I ask just one last question? Thank you. Taking us back just to the briefs and the way it was briefed and the way it was argued below, did you believe, or did your former predecessors, did Mr. Erdman's counsel ever believe that the state training school was a viable option and present that to the juvenile court?
Based on the record, I do not think that anyone thought that the state training school was viable.
And was that based on what the JCO's testimony, or he wasn't qualified under the statute?
I believe that it was based on the JCO's testimony from my review.
Thank you.
Thank you. The case of State versus Erdman is hereby submitted, and the court will be adjourned for the morning.